So consequently, the recipients of the gift property lost its ownership rights. Singapore, one of the richest countries globally, and there will be some scenario whereby homeowner would like to transfer their home ownership to another person. So by doing so, is there any potential risk associated with this transfer of ownership? There are two main ways to do the transfer of ownership. Number one, by way of gift during the donor's lifetime, known as inter-vivos gift. Number two, by way of gift after the donor passed on, pursuant to a will. So, these two methods, does it applicable to HDB or is it only applicable to the private property? In fact, these both methods are applicable to HDB and the private property when we are looking forward to do a property transfer. But today, we are going to talk about the first method. Can you give away your property to someone else without any monetary compensations? Yes, you can do so by effecting a deed of gift from a transferor to a transferee. As for HDB, the procedure is not so straightforward as HDB regulations are more stringent. You can only do so for the property transfer to immediate family member, for example, spouse, parent, siblings, children. And even you want to do so, need to follow certain limited reasons. And as for HDB owner who wish to transfer their HDB ownership to immediate family member, can only do so for limited reasons, such as there's a change in family structure, for example, divorce, demise in ownership, or even marriage. And this all is subject to the HDB approval. When it comes to private property, there's a few things to keep in mind before finalizing a deed of gift. These are the things to check and review before proceeding. First, is the property still under mortgage loan? Are you utilizing any CPF contribution for the property? Because if the property is still under any financial obligation like a loan and CPF contribution, you might not be able to do the property transfer. The recommended approach is to settle the mortgage loans and the CPF in the property and accrued interest. And this all payment require cash payment. Once these financial obligations are settled, the transfer of the home ownership will be much more straightforward. There are some rare instances despite having these existing increments, a person is still able to give the property. But this is very rare and uncommon. You need to check with the CPF boards and bank to explore the alternative possibility. But most of the time, it will not be approved. In summary, the best course of action is to clear the mortgage loan and settle the CPF in the property before proceeding with the property giving. And another important thing to take note is that stamp duty still apply for the property transfer. If you are transferring your property to another party, that individual is required to pay the basic stamp duty based on the current market value. Likewise, if you own the property less than 3 years, you are required to pay the standard seller stamp duty based on the current market value. If the individual who is transferring the property, known as the giver, is declared bankrupt within 3 years of completing the deed of gift, the gift and its associate transaction could be invalid. The bankrupt's official assignee can be the one deciding it. The OA official assignee can approach the court seeking specific order. If the court approves the order, the gift, the property, will be reclaimed as the bankrupt's estate. So consequently, the recipients of the gift property lost its ownership rights. Another important consideration pertaining to the gifted property mortgage, given to its potential of invalid transaction for the gifted property, the bank are often reluctant to borrow the loans. So the buyer will face issue getting loan to buy this gifted property. Well, this overview provides you with a brief insight of the complexity surrounding living property. For a deeper understanding and a tailored advice, get in touch with me and consult a legal firm.